everyone. My name is William Baronato, or Bill, and I will be discussing with you guys the Americans with Disability Act. I will be talking about what is the Americans with Disability Act, the 5 titles of the American with Disability Act, a little bit about service animals, and a little story about Whole Foods as well. So what is the ADA? The ADA is a civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life, including jobs, schools, public transportation, and all other public and private places. The purpose of this law is to make sure that people with disabilities have the same rights and opportunities as everyone else. The ADA gives civil rights protections to individuals with disabilities similar to those provided to individuals on the basis of race, color, sex, age, and religion. It guarantees equal opportunity for individuals with disabilities in public accommodations, employment, transportation, state and local government services, and telecommunications. The ADA is divided up into 5 titles or sections that relate to different areas of public life. For the first title, we have Title I, which is Equal Employment Opportunity for Individuals with Disabilities. This title is designed to help people with disabilities access the same employment opportunities and benefits available to people without disabilities. Employers must provide reasonable accommodations to qualified applicants or employees. A reasonable accommodation is any modification or adjustment to a job or work environment that will enable an applicant or employee with a disability to participate in the application process or perform essential job functions. This portion of the law is regulated by the U.S. Equal Employment Opportunity Commission. Employers with 15 or more employees must comply with this law. The regulations for Title I define disability, establish guidelines for the reasonable accommodation process and address medical instances as well. We also now have Title II, which is state and local government on the basis of disability in state and local government services. Title II of the ADA prohibits discrimination against qualified individuals with disabilities in all programs and activities that are part of the state and local government services. It clarifies requirements for the Section 504 of the Rehabilitation Act of 1973, as amended for public transportation systems that receive federal financial assistance. It also establishes detailed standards for operation of public transit systems and commuter systems like buses, Amtrak, PECO, everything like that. PECO. This title outlines the administration processes to be followed, including requirements for self-evaluation and planning, requirements for making reasonable modifications to policies and procedures where necessary to avoid. And going off that, we also have now Title III, which is the non-discrimination of disability by public accommodations and in commercial facilities. This title prohibits the private places of public accommodation from discriminating against individuals with disabilities. Examples are, as you can see, public pools, hotels. This title sets the minimum standards for accessibility for alterations in new construction areas of facilities. It also requires public accommodation to remove barriers in existing buildings where it's easy to do so without much difficulty or expense. Now we also have Title IV, which is our, actually I am ahead, I'm sorry. This title directs businesses to make reasonable modifications.
I'll give clues over here. See this tie is down, so one of you can say.
Okay. And we're going to go on to Title IV right now. This title requires telephone and internet companies to provide a nationwide system of interstate and intrastate telecommunication relay services that allows individuals with hearing and speech disabilities to communicate over the telephone. This also requires closed captioning for federally funded people as well. And we're going to go right into Title V, which is our miscellaneous one. Final title contains a variety of provisions relating to the ADA as a whole, including relationship to other laws, state immunity, insurance policies, prohibition against retaliation and coercion, and of course the use of illegal drugs. Now after that, we also have service animals. Service animals are defined as dogs that are individually trained to do work or perform tasks for people with disabilities, helping blind people move around, alerting deaf people, even alarming people when they have seizures. There's a difference between service dogs and service animals that just provide comfort. If they're there just to provide comfort, they're not considered a service animal. They're just some pretty dog in a purse for most people. They have to be working animals for a certain reason. Now, I'm going to talk about my coworker Tim at Whole Foods Market. Tim is actually a little person. He stands at about 4'2" and cannot reach certain things in the department. We have step stools littered all around the department in order to help him reach certain things. Otherwise, you have people like this guy right here being really rude and trying to just make his life a living hell. Otherwise, though, even without that, the step ladders, he's my supervisor. I love him to death. I do not see him differently than anyone else. I think he's one of the most wonderful people to work with, and I don't see anything wrong with him as well. Now we're going to be wrapping this up as I talked about what is the ADA, the 5 titles, and a little bit about service animals and Tim. Next we have Jessica and the EEOC.
Hi everyone, I'm Jess and I will be discussing the Equal Employment Opportunity Commission, which most of us probably know better abbreviated as the EEOC. Going into the HR field, it's very important for us to understand who they are, what they do, and what happens when a charge is filed with them. They're basically responsible for enforcing the federal laws that make it illegal to discriminate against a person for their race, color, religion, age, disability, basically anything a person can be discriminated against for. And with these, they have to follow some laws and guidance. The federal laws that prohibit the workplace discrimination are passed by the Congress and signed by Mr. President up there. And you've already learned about the different federal laws, such as the Civil Rights Act and the ADA from Carla and Bill. And there are also regulations that implement these laws, and they are found in the Code of Federal Regulations. When they want to make a new regulation, they will usually issue a notice of proposed rulemaking first, just to give the public a time to comment on it before it's being approved. And here's a notification that an employer will get if they are being accused of discrimination. And what was I going to say? Oh, this does not mean that discrimination occurred. It just means that the EEOC has the authority to investigate to see if there was discrimination in the workplace. And it doesn't always become a huge court case either. Many of the times, they will choose to do mediation or settlement, and the EEOC will tell them if they're eligible to go this way, and then they can decide with each other. And if you're ever bored and you want to go on the EEOC website, you can see how many charges there were in each state and for what exactly. So in Texas, they had the most at 9,308, while Maine had the least at 30. And this obviously depends on the size, and it ranges between all the states. So here's a scenario that might help you better understand what happens if your company is charged by the EEOC and what you would do with an HR representative. So say you're the director of HR for TD Bank, a company with about 85,000 employees, and a bank teller is getting inappropriate messages from her supervisor, and when she refuses to be with him, the messages get worse, so she tells the head manager, and he ignores it and instead retaliates by giving her less hours to work a week. So she files a charge for sexual harassment and retaliation. So you'll be notified by the EEOC with that notice that I showed you earlier, and you may be asked to do a couple different things during the investigation. One would be to submit a position statement, which is when you tell the organization's side of the story. You may also have to submit a request for information, which is when you would submit personnel policies, the personnel files of the people involved, and any other relevant information. So it's important to have all this information organized and at your fingertips so you can give it whenever you are asked for it. You may also have to permit an on-site visit or allow them to hold interviews with witnesses. You really should be prompt and work with the investigator during this process because the average amount of time it takes is about 10 months, and you don't want to deal with that stress for that long of a time. So when the investigation's over and they make a decision, they will send you a letter of some sort, and if there was not discrimination, they will send the charging party a dismissal and notice of rights. This tells them that they can file a lawsuit in federal court. If there was discrimination, both parties will receive a letter of determination stating that and inviting the parties to join the agency in seeking to resolve the charge through an informal process called conciliation. If conciliation doesn't work, then the EEOC has the authority to take it to federal court. And if they don't feel like litigating for whatever reason, then they will send the charging party a notice of right to sue, which again means that they can just take it to federal court and file a lawsuit within like 90 days. So to go to a different part of the EEOC, when I first started at Archer & Grinder in the HR department, I had to do an EEO-1 survey, which is basically a report that's mandated for many companies where they ask for the employees' job category, race, ethnicity, and gender. And there's going to be an example of one for you, popping up now. And as you can see, well, I hope you can see, yeah, there's job categories on the side with executive senior level management at the top, service worker at the bottom, different job categories that you could be put in, sales workers, administrative support, and at the top we have race ethnicity, which is split up into non-Hispanic or Hispanic, or non-Hispanic or Latino and Hispanic or Latino, and then it's split up into gender. And then there's 6 different categories that an employee can be put in for race or ethnicities underneath. And then a completed one will be shown right here. And you can see they total everything up at the bottom and on the side, and they even have the totals from the previous year. This way, the EEOC can see if there's a major jump in one certain area. So again, it's very important for you to be very accurate with this information, or they'll be coming for you for something. So as a recap, I wonder what the EEOC is, what happens when a file is charged with a company, and what the EEO-1 survey is. Up next, we have Megan doing the FMLA. And thank you.
So pause just for a second.
Let's pause.
So when Jessica said we'll be coming for you if you don't get that, that's qui pro nomina justitia sequitur. We'll be coming for you.
Oh my God.
No, just that is the bill that showed that up there. That's the Department of Justice motto. It means who prosecutes, we who prosecute on behalf of justice, or we'll be coming for you.
Thank you.
Anyway, that's
Okay.
just going
Thank
through
you.
the mind. Jessica, that was a lot of good information.
Thank you.
Alright, so my name's Megan and I'll be talking about the Family and Medical Leave Act of 1993, also known as FMLA. I'll be telling you guys all about the process of it, a few court examples of it, and I'll also be talking about the New Jersey FLA, which is the New Jersey Family Leave Act, which stems off of the Family Medical Leave Act. So to start off, what is FMLA? So FMLA is a United States labor law that requires employees to provide employers with unpaid job-protected time off for medical reasons, for either for themselves or for a family member. The FMLA was intended to balance the demands of the workplace with the needs of families. So eligible employees for FMLA, they have to work for a covered employer. They also have to have worked for at least 12 months with the company. They have to have at least 1,250 hours of work within those 12 months, and they have to